We've got major movement in the nationwide push to pull suppressors and short-barreled rifles out from under the NFA. And once again, the Trump DOJ, under Pam Bondi's direction, is walking into court defending the NFA, even after Congress nuked the $200 tax down to zero. This is yet another moment where the federal government is clinging to outdated authority that no longer exists. But this time, the plaintiffs are coming in with a unified coalition that is bigger, sharper, and far more aggressive than anything we've seen since Bruin. So let's walk through everything happening in this critical constitutional fight. Transition into the bill. All right, now let's get into the heart of this legal fight. The big beautiful bill did something massive. It took the NFA's $200 tax, the foundation of the entire NFA structure, and reduced it to $0. H.R. 1 passed, tax gone. But as many of us said from the beginning, that wasn't the finish line. That was the starting gun. And now the second phase of this battle has begun. The coalition lawsuit. A coalition of major Second Amendment organizations, GOA, FRAC, Silencer Shop, Palmetto State Armory, Silencer Co., has teamed up with 15 states. Together, they filed a lawsuit taking direct aim at the ATF and the constitutionality of the NFA itself. They didn't just file the suit, they filed a motion for summary judgment, which is the legal equivalent of saying, we don't need a lengthy trial, the facts are clear, the law is clear, judge, end this now. And naturally, the Trump DOJ pushed back with a response defending every inch of the old NFA system. The DOJ's tax power argument. Here's the first big argument from the DOJ. Even though the tax on individual items is zero, the NFA still imposes a special occupational tax on manufacturers, dealers, and importers. And because that tax still exists, they claim Congress still has taxing authority to enforce the entire NFA regulatory framework: fingerprinting, registration, approvals, background checks. Their logic boils down to this. As long as one tax remains somewhere inside the NFA system, the entire NFA survives. This is straight out of 1930s New Deal era constitutional theory. Not exactly the world we live in after Bruin. The DOJ's Commerce Clause argument. The DOJ also leans hard on the Commerce Clause. They argue the NFA regulates the interstate market for SBRS, SBSS, suppressors, and AOWS. Manufacturers cross state lines. Distributors cross state lines. Dealers cross state lines. Therefore, according to them, Congress has full authority. But they take it even further. Even if you make a suppressor at home, never sell it, never travel with it, never leave your state, they still claim jurisdiction, arguing that interstate activity creates a gaping hole in their enforcement scheme. This is D.C. reaching into your workshop, your garage, your state sovereignty. It's the classic federal mindset. If anything escapes our control, we'll expand our control. The DOJ's Second Amendment argument. On suppressors, the Trump DOJ relies heavily on the Fifth Circuit's ruling in U.S. v. Peterson. In that case, the government essentially admitted suppressors qualify as arms under the Second Amendment. But the court upheld the NFA anyway, calling it a shall-issue licensing system, similar to a concealed carry permitting process. So the DOJ's argument is, if shall-issue systems survive under Bruin, then the NFA survives too. But the plaintiffs absolutely disagree. Plaintiffs' core constitutional argument. Here's the plaintiffs' main strike. The NFA was upheld historically only because it was tied to an actual tax. The registration, fingerprinting, and approval requirements were secondary tools designed solely to enforce that tax. Remove the tax. Remove the constitutional justification. It's that simple. They also dismantled the occupational tax argument. The occupational tax is a flat fee that applies to businesses. It has nothing to do with individual firearm ownership. It cannot justify maintaining a registry of untaxed suppressors or untaxed SBRS. Plaintiffs on the Commerce Clause. The plaintiffs go further and attack the Commerce Clause justification. They argue, the NFA was never written as an interstate commerce regulation. It was written as a tax statute. And the government cannot explain how a citizen building something entirely inside their own state affects interstate commerce in any meaningful way. Their brief states plainly, regulating intrastate possession for public safety is a police power, and the Constitution reserves police powers for the states, not the federal government. This is one of the strongest constitutional angles the plaintiffs have raised in years. Where the case stands now? So here's the situation. Multiple lawsuits are moving through the courts. The plaintiffs are coordinated. Congress already undermined the legal foundation of the NFA by eliminating the tax, and the Trump DOJ is fighting tooth and nail to keep the old structure alive using arguments about taxation, commerce, and licensing systems. But here's the key takeaway. This is not the same kind of NFA challenge the Supreme Court just rejected. Those cases did not have a congressional tax repeal to build on. This one does. This is a brand new legal environment, and the courts have never had to confront this combination of facts before. This could be the biggest structural challenge the NFA has faced since it was passed in 1934. As new filings drop, as hearings get scheduled, as judges begin reacting, I'll be here breaking all of it down so you stay ahead of every development. If you found this breakdown helpful, hit like, drop a comment, and make sure you're subscribed. YouTube has a long track record of accidentally unsubscribing people in the gun and political commentary space.